So good afternoon. My name is Ruben Castillo. I'm privileged to serve as the Chief Judge of this district, and we're happy to host what I'm going to call Voting Rights Part 3, or the third of the trilogy. I'm sad to see it end because this programming has been really cutting edge. And if you're following, the newspapers and what is going on at the Supreme Court, and you look at the first session, you look at the second session, and now you see the third session, you could be following this in the New York Times, any newspaper, or even the U.S. Supreme Court. Just January 10th, the U.S. Supreme Court heard an argument about the Ohio voting purge process. That issue, I think, is going to be addressed by this afternoon's panel. If you look at what occurred on January 9th, when a 3-judge panel, North Carolina, threw out a congressional map finding an unconstitutional gerrymander, I think that whole topic was addressed in Part 2. Or look at what happened January 23rd when a Pennsylvania map was thrown out. That whole topic of gerrymander is pending before the Supreme Court, and it'll be interesting to see how all of this lines up. I said before, I can't think of a more important topic than voting rights, so it is, my hat is off to the Seventh Circuit Bar for coming up with this topic, and in particular, its diversity committee, for putting together this cutting-edge programming. No matter what your interests are, they're affected by the 3 programs that have been hosted proudly by the district court. My own personal interests have to do with the issue of guns. You saw the Seventh Circuit address that this year. I also happen to be the son of an immigrant. So I'm definitely interested in immigration, and I can tell you any immigration reform that's going to come from this Congress and from the president is very dependent on what goes on in elections that occur with respect to the U.S. Congress and nationally. I'm also very interested on my mother's side in the island of Puerto Rico, which has been devastated by Hurricane Maria. Which I will shortly visit to see firsthand what it looks like. And I can tell you one of the things that was held up by the budget stalemate was aid to Puerto Rico. So is very hurtful. It's hurting people. It's killing people on that island. And that's something that shouldn't be happening. So all I can say, bottom line, is elections have consequences. And if you come here tomorrow in this very room at 3 o'clock, we're going to swear in the new U.S. attorney. That U.S. attorney was named by our new president. I'm going to make 2 predictions here today. I think I'm going to predict that you're going to see new additions to our court and to the Seventh Circuit Court of Appeals very shortly, later this year. So elections have consequences, and we need to know what our history is and how these cases play out in court. So my hat is off to the Seventh Circuit. We're thrilled to host this. Here's my last prediction, and this one I can easily make happen. I want to announce for the first time that our court is going to honor its history. We're coming up on our 200th anniversary next year. So we're going to open up on May 1st. Happens to be Law Day. Also happens to be the date we're going to have our pro bono ceremony in this very room. We will open up our first history museum on May 1st on the 21st floor of this courtroom. And I can assure you that at different points, that history museum will honor the various voting rights cases that have been litigated in this building, of which I was proud to participate in some of those cases. So having made that unpaid announcement, and I'm not going to pay myself for making that announcement, my next duty is to call up our great president of the Seventh Circuit Bar Association, Beth Harrington, to give you her personal greetings. Beth Harrington, thank you.
Hi, good afternoon. As Judge Castillo noted, my name is Beth Harrington. I'm the current president of the Seventh Circuit Bar Association. And on behalf of the association, I just wanted to say thank you for being here today. We're very excited about this program. We think it's very important and very timely. I'd personally like to thank the Diversity Committee and Margot Klein in particular for really spearheading these various topics that we've been covering at our free CLE programs. So we're really thrilled. Thank you, Margot. And also, I wanted to make sure that I put in my own public service announcement, unpaid. As the Seventh Circuit Bar Association president, one of the things that we do is we plan an annual meeting. This year's annual meeting will be held in Chicago on April 29th through May 1st. We will be covering many different timely topics, including an additional panel on voting rights issues. So I encourage all of you to go to the Seventh Circuit website, find out information, and please join us at the annual meeting because it's always filled with fantastic programming. Two other quick things. You may be aware that the Seventh Circuit honors pro bono and public service. And every year at our annual meeting dinner, we award people that have done outstanding work in the areas of pro bono and public service. Currently, we are now accepting nominations for members of the bar who have performed such service over the last year. The nominations are due by February 16th. And as you walked in today, you may have seen when you signed up for CLE that there was some information regarding those awards. So please make sure if you're aware of somebody that's deserving of one, that you consider submitting a nomination. Along those same lines, the Seventh Circuit offers scholarships to those that, members of the bar that perform pro bono and public service work. Every year, we award scholarships to those folks, and as part of that scholarship, we award them a free membership to the Seventh Circuit Bar Association, as well as admission to our annual meeting that is on April 29th through May 1st. So if you know of anyone or you are somebody that you think would be eligible for those scholarships, I definitely encourage you to submit your forms. That information is in the back, too. You can also find out information about the Pro Bono Awards, as well as the scholarships on our website. So if I would just like to, again, say thank you all for being here. And without much further ado, I'd like to turn it over to our panel and our moderator.
Thank you. Good afternoon, everyone. I'm Ami Gandhi, and I'm the Director of Voting Rights and Civic Empowerment at Chicago Lawyers Committee for Civil Rights. And I couldn't agree more with a comment that Chief Judge Castillo just made about the importance of reflecting on our history when we talk about voting, when we talk about our civic life. And part of that history that I'd like us to reflect on for a few moments before we hear from our stellar panel of speakers is the history of our election systems, of our voter registration systems, the fact that many of these bureaucracies were set up in our country's history explicitly or otherwise to exclude part of the electorate from participating. And that's something we're concerned about at Chicago Lawyers Committee for Civil Rights, and that underpinning of our system in Illinois and across the country is something that we have to confront if we want to be realistic about how to try to improve things from here on out. And whether it was freed slaves who were excluded from voting in southern states, immigrant citizens in the north, low-income community members all over the country, that kind of exclusion was real, and the vestiges of that remain even in our voting system today. Around that time that such bureaucracies were introduced, we also saw the burden shifting from government authorities having the responsibility to keep the voter rolls up to date, to the burden shifting to community members like us having to proactively register and keep our registration and our participation active. Now, some aspects of bureaucracies and election systems and formalities can certainly be positive. I am not trying to overgeneralize by any means. we're all interested in this day and age in increased security and accuracy of our election systems, regardless of our political affiliation. And we want to try to strike a fair balance as we move forward. In Illinois, for example, we're by no means perfect. People can certainly feel free to crack jokes about our history of voting and elections and government in Illinois and Chicago. And we have made many steps, but perhaps because of that ugly history, we've made many steps in progress in recent years. And with some of those innovations, such as automatic voter registration that became law last year, it was even done on a bipartisan basis. Much of the implementation work for innovations like automatic voter registration still have yet to be completed, and it will require continued sustained community involvement and political will, but there is excitement statewide about these improvements to our voting system and these imminent opportunities to improve our election system. When we hear today about some of the trends locally in the Midwest, all over the country, relating to voter access, I'm betting you that it'll plant a seed in each of your minds about how, in a tangible, real-life way, we could improve our systems right here at home or wherever you're tuning in from. And for many of you who are here from the Illinois legal community, I invite you to join us for our upcoming nonpartisan election protection effort that will take place on March 20th during our primary election here in Illinois. We have volunteer opportunities available, and we'll soon be announcing details about CLE trainings and volunteer shifts. And so please sign up on our sign-up sheet that's immediately outside this room, or find one of us from Chicago Lawyers Committee before you leave if you'd like to be part of that force. And you can imagine that in 2016, we had an overwhelming number of volunteers. We were able to achieve a lot of successes for voter access because we all worked together to do that. Every time there was a presidential debate, we had a lot of signups in the middle of the night for election protection volunteers. And we hope to have a robust program again for our March 20th election protection program. And we also have volunteer opportunities, not just in the area of voting rights, but other areas of civil rights work as well. So we invite you to participate in that. We have opportunities in our settlement assistance program, education equity project, community law project, hate crime project, housing opportunity project, and police accountability project. I had to read from the list to make sure I didn't forget any of these important areas of work, and many colleagues are here today as well to talk to you about those opportunities. Before I pass it on to our wonderful speakers, I wanted to give a thank you again to the Seventh Circuit Bar Association for its commitment to discussing and examining this issue of voting rights. And this is, as was just mentioned earlier by Beth, this is the third in a series of voting rights programs. And one of the issues we won't talk as much about today because it's so important that we're devoting a whole additional program to it in the near future, which is voter access issues for community members in the criminal justice system. So stay tuned for an announcement soon about the specifics of that. And we'll move on to why I'm really here today and why all of you, I'm sure, are here as well, is to hear from our excellent lineup we have. So all the way to my left, we have Wendy Underhill, who is the Program Director of Elections and Redistricting at National Conference of State Legislatures. And next to me here, I have Nicole Austin Hillary, the Director and Counsel of the Washington, D.C. office of Brennan Center for Justice at NYU School of Law. And we also have with us Justin Levitt, Professor Justin Levitt, Professor of Law and Associate Dean of Loyola Law School. And with that, I will turn it over to Wendy to begin our presentations for today. And we'll have plenty of time for questions at the end, so please jot down your notes about your great ideas for questions. Thank you.
Well, thank you, Ami, and thank you to Margot for having us come, and thank you to the Seventh Circuit for this. I flew in last night from Denver, and I packed my long johns, both the bottom half and the top half, but that's because when I first arrived in Chicago ever was to go to transfer into Northwestern, and I arrived in January, it was -2, so I had this image that if I was going to come in January, I had to come prepared. I did not use those garments today, I'll tell you. Okay, so I am with the National Conference of State Legislatures. We have 7,383 legislators around the nation and 25,000 staff people, and we try to support the work of all of those folks. About 1,000 of those legislators are on the committees with jurisdiction over elections. So now I've reduced the number I have to deal with from 7,000 to 1,000, and of those, 99 are chairs of elections committees. So those are the folks I particularly look to. The work that we do is bipartisan. At the very core of NCSL, we have bipartisan structure at the top, and it's longstanding in that regard. And because of that, we produce for our members factual information. I'm a good numbers counter. I can count to 50 really well. After 50, I'm not so sure, but I'm not an attorney, but I'm a counter instead. So I can tell you how many states do one process or another, as you'll see going along here. And because the work that we do is nonpartisan, what I'm going to be offering to you today is a 18-year chronology of some of the things that you might think of when you think of voter rolls, voter ID, and voter access. So this first slide shows that in 2017, there were 2,373 bills introduced on elections. And in my mind, that number indicates that there's a great deal of interest in the mechanics of democracy. That's a lot of action. Now, they're not all big and important bills, but still there's a lot. And then we had 267 enactments last year, and both of those numbers are about on par with where we've been for the last 6 or 8 years. So about a tenth of the bills get enacted. Last year, all 50 states and DC had bills introduced, and 41 states passed at least one bill. So that just gives you kind of the scope. And let me just say, I cannot count to 2,373 well enough, so just don't ask me about the details of every last one. I've kind of put them into some categories for us. Most of the time when I talk, voter ID is what comes up first, so I went ahead and put it on the screen first. This is chronology. The states that you see in green are the states where a voter can show up and vote without showing any kind of an ID at all and not even be asked for one. And if you start on the far left, you've got 2000, you go to the right, you've got 2018. It's obvious that more states now do require some kind of an ID than used to require some kind of an ID, so as the green shrinks. And then the yellow and the red are states where something is asked or required of the voter. Now, the difference there is the red is required, and the way we've defined this, and other people could have a different line in the sand, is that if the voter has to take an action, if the voter who doesn't show ID at the polls has to take an extra action step after the election to make sure that their vote is counted, then it goes in that strict red category. And I think that the states that are in your circuit are important in this. Indiana was the state whose original strict voter ID law went to the Supreme Court, where they said it was okay to keep it in place at least until harm could be shown from it. And then Wisconsin has been, its voter ID law has been in many, many courts over the number of years since it was enacted. So what we can see, I guess, is that there is more voter ID. If this is a question of blocking people from voting, I'm sure the other panelists will be able to talk about that a little bit. I think the key really is more so the difference between the red and the other two categories than it is between the green and the other two. And I'll be interested in what you all have to say about that. So some people might say on the flip side is allowing people to vote before election day, pre-election day voting. Now, I made up that term, pre-election day voting, and it has not caught on. I really wish it would. It includes early in-person voting, no excuse absentee voting, and all mail elections where everybody is mailed a ballot. So you take all three of those and wrap them up. It means that voters have the opportunity, if they choose, to vote before election day during some window, and it could be a week, it could be 6 weeks before election day, giving them a wider amount of time to be able to fit in this piece of democracy of civic engagement. So again, on the left we have 2000, on the right we have 2018. Back in 2000 there were 26 states that allowed people to vote before election day, and now there are 37 states that allow people to vote before election day. So there's clearly been an upward trend. Most recently Massachusetts permitted early in-person voting, and Minnesota before that with no excuse absentee voting. So It's a little quieter trend, and I'm not sure it's done. We're seeing in many of the states around you, in fact, we could look at this. This is a map of the states that, the blue ones do offer a pre-election day option, and the green states don't. So what I noticed is that almost all of the states that are in green do have bills this year to create early or no excuse absentee voting. That doesn't mean that they're going to pass. It depends entirely on the state, but I think you could look at Michigan and Missouri as states where there might be action on that front. And I also want to point out that two of these states, Virginia and Rhode Island, virtually, that are in the green, they virtually have no excuse absentee voting. In Rhode Island, all you have to do is say, I won't be able to vote on election day. You don't have to really give an excuse, and yet you still have to check that box. So that's why we keep them in this category. And in Virginia, there's 19 excuses that are available to you. Again, though, you have to choose one of them to get your absentee ballot beforehand. I do want to mention, just back on the voter ID for a moment, this coming in 2018, we have legislation again from a number of states to enact voter ID laws, and I think states to watch on that are Maine and Nebraska. So I don't know whether they'll get it through or not, but that conversation about voter ID is not over. The conversation about pre-election day voting is also not over. So on this slide, I'm looking at registration, and I think you mentioned, Ami, that's one of the steps that a person has to take before they can vote. At least that's true in 49 states. In North Dakota, they claim they don't have voter registration. So if the first step is registration, then folks want to make registration a reasonable thing for people to be able to get. So what we've done here on this slide is put 3 policies that states can adopt that should make it easier for people to get registered. And I want to say, I'm not sure that if you're that getting registered necessarily makes you vote, but not being registered keeps you from voting. So anybody who says doing these policies is going to increase turnout, I want to see the numbers before I can get on board with that. Okay, yellow is online voter registration. Again, starting in 2000, what a surprise. Nobody had online voter registration. I mean, we hardly knew what email was, and websites were exciting. But now there are 37 states that have online voter registration, and mostly these are for people who have a state-issued driver's license or ID card. They can go online with that information and register to vote, and they don't have to fill out a piece of paper. It's good for the election administration side as well as it's hoped for the access side. And then the red line is election day registration. So in 13 states, it used to be 5 states. People who aren't registered to vote can show up at the polls, say, hey, I never quite got registered, but I want to register and I want to vote today. And they can do both of those things with one-stop shopping. And there has been this upturn in this recently, and I think the reason it's starting to pop up is partly that it's like the opposite of voter ID. Voter ID people might think of as restrictive, and election day registration people might think of as opening the door. So that in states with Democrats in control, election day registration is popular. But that's only a piece of it. The other piece is that technology is making it possible to know that if somebody registered at polling place number 1, that they did that, and they can't then go to polling place number 2 and cast a second ballot and get away with it. So technology is helping with that. And then the blue line here is automatic voter registration, and that began really in 2015 when Oregon moved in that direction. And you mentioned that also, Ami, that it's true here in Illinois. And I actually point to the Illinois bill as the one to look for because it did have bipartisan support. And at this point, there's 9 states and the District of Columbia that claim they have automatic voter registration. So here's a situation where since 2000, the registration process has become easier and perhaps will continue to be easier. I think that now in Washington and New Jersey, where both chambers and the governorship are held by Democrats, it's likely we'll see election day registration and online voter registration in New Jersey, which does, no, sorry, forget that, and automatic registration. I think we'll probably see that this year in both of those states. Any of those predictions I make, by the way, do not bank on them, and don't tell anybody that I was making any guesses, please. So that part of registration was about how do you get on the rolls, and I think one thing we want to talk about here is how are people removed from the rolls, and this is a job that every single state has to undertake. They have to do list maintenance, and there's a lot of federal guidance here, which I hope you'll talk about, or one of the two of you will talk about, that says it's not okay to let deadwood stay on the rolls, and at the same time, it's not okay to take people off prematurely. So states are looking for that in between. So they all do it. On the left, I've put some ideas about places that states can look for data to learn about what's going on with their voters, and then generally speaking, they contact the voter and say, we have information that you are deceased. Tell us if that's premature. And so they can check all of those on the left. And then there's the Electronic Registration Information Center, and I just want to mention that because while it doesn't always take legislation for states to join it, it is the latest thing, and it's again a place where technology is our friend. The 23 participating states throw all of their information into a data hat, is the way I see it. I'm sure technologists here would not like that description. And it's churned, and then reports go back to the states saying these are potential people who are on other rolls in other states or registered twice in your own state. And then it's up to the state to decide what they want to do with that information, and generally they follow the same procedures that they have used for other folks to get them off the lists as well. So it's new, more states are joining it all the time. One joined last year, one joined already this year, and it looks to be growing. I threw this slide in about security for elections. It does not actually fit the topic that we've been asked to discuss, but I want you to know that legislators are thinking about security for elections, as are most of you in the audience. And the 2016 election brought it to our minds that there could be attempts to get into voter registration databases, and certainly into campaign email accounts. That kind of a thing is very much happening. Legislators are trying to figure out what's their role in that. How can they stop it? It's impossible to pass a bill that says we will have secure elections. You have to operationalize that concept. And so that's a lot of churning going on now. But there's one place that in 2017 we saw a change, and it might be related to that security, and it might also be related to just some other artifacts of where we are with voting equipment. But last year, states did put money into replacing technology in a way that has not been true in the years prior. And here's a few of them. Utah with $275,000, that doesn't go very far even in a not very populous state, but at least they made a nod that the state had a role at some level in funding elections technology. And this is my last slide for you, and you won't be surprised that the red represents states that are held by Republicans, and the blue represents states that are held by Democrats, and the purple are ones where it is a mix. And we start in 2000 and we go to 2018. And the way I'm counting this is when both chambers are held by Republicans, they become red. And I'm leaving the governor out. And I've counted up to 49 here because Nebraska has a unicameral, nonpartisan legislature, so it just plain doesn't count in this analysis at all. So if you start in 2000, you can see that there were somewhat more democratically held states than there were Republican-held states. And now you can see a huge number more Republican-held states than Democratic-held states, and the drop-off was primarily in 2010. That's one of the takeaways. We absolutely have more states with Republicans in control of the legislature. But I do want to note that the purple here has fallen off as well. There are fewer states with mixed control in the legislature, and we could discuss, if you want to, why that might be. My guess is as good as anyone else's on that. So that's where I want to end. We've got more Republicans, we have more voter ID, we have more options for getting on the voter rolls, we've got more options for getting off the voter rolls, or at least ways to check for it, more interest in security. And that's it. How did I do on time, Margot? 13 minutes on the dot?
You didn't get the hook, Wendy.
Okay.
Thank you so much. I will switch, Nicole, to your PowerPoint.
Okay, great. So good afternoon. Again, I'm Nicole Austin Hillary. I'm the director and counsel of the Washington, D.C. office of the Brennan Center for Justice. For those who don't know who we are, the Brennan Center for Justice is a national advocacy legal think tank. We were founded in honor of former Supreme Court Justice William J. Brennan when he stepped down from the court. A group of his clerks got together and they said, we need to do more than buy him a nice gold pocket watch. We need to find some way to keep his legacy and his jurisprudential thinking living and breathing. And the Brennan Center was born of that thinking. We like to use the tools of litigation, advocacy, policy, strategic communications, and research to do what we like to call fix those broken parts of our systems of democracy and justice. And clearly, the issue of voting and our democracy and making sure that as many Americans as possible can access our election systems is a core part of what we like to say is protecting our democracy. And my role in Washington is to oversee how we advocate on behalf of these issues. So I get to work with all those fun people in Washington that you see on the news every night, the members of Congress, the administration, and all the relevant folks in the agencies. Now, we actually planned this perfectly, Wendy, because Wendy is the numbers person, as she said, and I am also not a person who can count up to 267. That's why I went to law school. If I could have counted better, I might have been a doctor or something interesting like that. But what I do want to talk about is she's laid out the numbers. I want to talk a little bit about the meat on the bones of those numbers. What's really behind those numbers? Because there is a story to tell in terms of where we are in voting in the United States. Here's where we really got started. The Shelby County decision that came down from the Supreme Court on June 25th of 2013 really changed the landscape. As most of you know, when the Voting Rights Act was passed in 1965, there was a provision of the Voting Rights Act called Section 5. And Section 5 is that provision that said that states that had historically been guilty of discriminating against individuals in the realm of voting had to have their new voting laws changes pre-cleared by either the highest court in the country, in the District of Columbia, the highest federal court in the District of Columbia, or by the Department of Justice. So that meant that we got notice whenever one of those states or jurisdictions, because it's not just states, there were also parts of some states that were covered under Section 5, that whenever they were going to make changes, those changes had to be given a stamp of approval. Well, when the Supreme Court struck down, actually what they did was they struck down Section 4, but Sections 4 and 5 work together, kind of like an engine in a car. Without one, you don't have the other. And when they struck down Section 4, that changed the landscape. And that meant that states across the country that had been previously covered could make changes, and they didn't have to have them approved by anyone. In fact, on the date of that decision, June 25th of 2013, we saw the Secretary of State in Texas get on the news that night and say, now this voter ID law that we want to get passed, we're going to do it now, because we no longer have to deal with getting it pre-approved by the Department of Justice. And that's what really changed the landscape, and that's when we started to see, as you heard Wendy say, if you look over the last 6 years, you see an uptick in the number of pieces of legislation that have been introduced across the country by state legislatures to try and deal with issues such as voter ID, changes to early voting, changes to absentee balloting, changes to citizens' requirements with respect to voting. All of that came as a result of the Shelby County decision that made it easier. But what that also did was that made it harder for us to really protect the interests of voters. Because without the notice provision that we had with Section 5, that meant nobody had to be told ahead of time when changes were going to be made. That also meant that lawyers who worked to protect the rights of voters didn't have an opportunity to try and protect those rights by heading off the actions of these states before they could actually get them enacted. That makes things a lot harder, not just for the voters, but also for the people who are trying to protect the rights of voters. So what does that look like now? Here's what we see across the country in terms of barriers and voting. Wendy already talked to you about some of the numbers, but let me just encapsulate that for you. 14 states had restrictions in place for the first time in a presidential election in 2016. We think that is directly linked to some of the changes we saw post the Shelby County decision. And that was really a change to the landscape, because never in a presidential election since the enactment of the Voting Rights Act had we not had those protections in place. We saw 6 states that had restrictions in place for the 2012 presidential election. That is a comparison for you. So while we still had the protection of the Voting Rights Act, only 6 states had restrictions in place. By the time we got to 2016, we were up to 14. And then we had 3 states with restrictive laws that have been enacted since the 2016 election. So it didn't stop. We still have many state legislatures that are continuing to try to implement new laws that we think have the effect of making it harder for many Americans to vote. And the Americans that are mostly impacted by these restrictive laws are people in very vulnerable categories. There are the elderly, they're poor people, they're students, and there are many people from minority groups who are most impacted by these restrictive laws. Where are we now in 2018? One of the pieces of material that I've shared with you all that you should either you're going to get or you already have as part of your CLE materials is a document that the Brennan Center put together. Once we started seeing these changes in state legislatures, we started putting together something we called the Voting Laws Roundup. And we do this every 2 years so that we can actually measure what is happening across the country. Are these thoughts we have and these inklings we have about what state legislatures are doing, is it true? What are they doing? Where are the changes being made? And how are these changes impacting voters? So we just did a new update on January 22nd of this year. And what we see is this for the start of 2018. There are 2 voter ID laws that are pending. We have registration restrictions in 1 state. Early voting is being challenged in 2 states. Absentee voting legislation is in 2 states. List maintenance legislation is in 4 states, and that's the legislation that looks at how voter rolls are maintained, which is part of what Wendy talked about. We also have 2 states that are dealing with minimum standards for these election rules, and we also have 1 state that is looking at a new law with respect to student voting and how students get to vote. Whether they get to vote in the state or the jurisdiction where they're actually a student versus where they grew up and where their parents live. And in 2018, we see an expansion of these kinds of bills. And this is just a categorization of what we're seeing. Wendy touched on some of these, but you should see as you see here, there are lots of categories. There are categories to help expand the vote with automatic voter registration, and I'll talk about that in a little more detail in a bit. We see same-day registration, online registration, portability, which deals with the ability to have your registration follow you. There are changes dealing with registration deadlines and where you can vote, the locations of polls, rights restoration, which deals with the formerly incarcerated having their rights restored, which is going to be a topic, as you've heard, for another panel with the 7th Circuit. Military voting, student voting, disability access, pre-registration, all of these issues are at play in the states across the country. And what I always like to tell people is that really underscores just how important voting is in this country. I have to tell you, sometimes I have people say to me, why is voting so important? And I tell them, you know what? You can be a person like me, one of those people who knew she wanted to be a lawyer ever since she was a kid because my 8th grade English teacher said, you have a big mouth, you should use it for good. And I know that means people like me do get to voice their opinions, but everybody doesn't have a big mouth and everybody doesn't have a place from which they can stand on high and say what they think and how they want their jurisdictions and their states to be run. That's what the ballot gives us all. And that's why it's so important that we protect the right to vote. And like Wendy's organization, the Brennan Center is a nonpartisan group. We don't care if you vote for the blue, purple, or multicolored man, woman, or other. What we care about is that the right to vote is protected. And when we see this panoply of laws that are being looked at and are being attempted to be enacted across the country, we have our antenna up because we want to make sure that as these laws are being enacted, that it is expanding the ballot and not making it more difficult for people to vote. Because that really is what's at the heart of our democracy in the United States. That really is the history of this country, that we have made it easier and we have made it more possible for as many people to engage in our elections process. Election security bills, I do want to talk about that a little bit. Wendy touched on that. It is such a crucial issue right now. I have to tell you, in Washington, I know folks keep hearing folks in Washington aren't working together. The Democrats and the Republicans aren't talking about anything. I have to tell you, they are talking about election security. Republicans and Democrats are in rooms. One of my very smart colleagues at the Brennan Center, Lawrence Norton, is a resident expert on dealing with election security and voting machines. He did a report on the state of election security across the country, and that report got many members of Congress actually thinking about this and saying, what can we do? And as a result, they are right now talking about what kinds of federal legislation we could put in place to make our election system far more secure. So that is something that, as we are even talking about issues such as voter ID and access to the ballot box, we have to look at how secure our elections are. That is crucial to our democracy as we move forward. And there are states, as you can see from this map, that are also looking at that issue in tandem with what's happening on the federal level. Now, I want to talk about this, and Wendy touched on this when she talked about, whether we make it easier for people to vote, that doesn't necessarily mean that people will vote. I have to tell you, we cannot talk about the issue of voting and voter rights without talking about how we get people engaged in the process. I tell people all the time, I go around the country and I talk about these issues, and I talk about what's making it harder for people to vote, but really have to tell you, one of the biggest issues we have in this country is not the number of voter ID laws that are being introduced, as difficult and as hard as they may be, but the biggest problem we have is voter turnout and getting Americans engaged in our process. What we see here is this, that in 2016, this is what our turnout looked like. Overall, in the presidential election, we had a 60.2% turnout. Of that, we had 44.9% of the Hispanic community that voted, 59.9% of the non-Hispanic Black community voted, and lots of people had questions. Was this because of voter ID? I will tell you, it was because of a lot of things, including many of the legislative efforts that we see going on around the country. So as we talk about this issue of what is the state of voting in the United States, we have to talk about, and I encourage you within your bar to talk about, how do we get Americans more engaged? And I'm particularly interested in and focused on how we get they tell me to stop saying they're the millennials, but I don't know what else to say. How to get the millennials engaged, because it is so important that the generations that are coming behind us realize the importance of voting and realize that that, again, is how they will be able to use their voices and how they will be most powerful in determining what happens in this country. Now, I want to tell you on the federal level, again, there are things happening in Washington. There is a pushback against some of these efforts to make it harder for people to vote in Washington. And I just wanted to give you a quick sampling of what some of those pieces of legislation look like. Right now, in the House and the Senate, there are pending bills dealing with automatic voter registration. And again, I know you all hear this term a lot, and you probably here in Illinois specifically know it very well, because you all are one of the shining examples of bipartisanship working well, because your state legislature passed AVR and your governor signed it into law, and it was very much due to a bipartisan effort. But automatic voter registration works just like this. If you go to a dedicated agency in your state, and for most states that have AVR, it's DMV, but in some states it may be the social services agency, and you go there to perform some other function, to get your license renewed or to get a car registered, they will ask you if you are registered to vote, and if you're not registered to vote, they'll give you the opportunity to indeed go ahead and register. But then once you're registered, you are registered. And that registration will follow you no matter where you live in that jurisdiction. So if you're like me, I'm a born and bred, proud Pennsylvanian from the capital city of Harrisburg. And if I grew up in Harrisburg and then registered to vote when I became an adult in Harrisburg, even if I moved to Pittsburgh or Philly, where they're about to be the next Super Bowl champs, that registration will follow me. And it also means that the state databases in all of these agencies are going to be talking to each other and communicating. So that even if you say grow up as Nicole Austin, and then you're one of those women who becomes hyphenated like I became, and you're all of a sudden Nicole Austin Hillary, a database is going to be talking and it's going to say, she's no longer Nicole Austin, she's Nicole Austin Hillary. So that then when you go to the polls on election day, this information is going to be updated. That's going to make it, again, easier for voters, and it's going to take the onus off of the voters and put it on the states, so that, again, barriers that may be in place that make it harder for people to vote or make people just say, I don't want to be bothered, those things are going to be moved out of the way through legislation like AVR. So we see that happening on Capitol Hill. We see a bill like the Voting Rights Advancement Act, which is meant to try to not supplant, but really strengthen some of the protections that we lost when the Supreme Court struck down Section 4 in the Shelby County decision. We have the Democracy Restoration Act, which this year has been introduced in the Senate. That is a bill that will seek to restore voting to the formerly incarcerated once they have completed their incarcerated period, whether they remain on probation or parole, whether they owe fees and fines. And that would only be, however, with respect to federal to federal elections, not with respect to state legislation, state elections. But the thinking behind that is that states are not going to run a dual system. That if we, with respect to federal elections, have a system in place where the formerly incarcerated can vote, that states will probably follow behind that. And again, election cybersecurity. There are pending bills dealing with election cybersecurity, as well as bills dealing with anti-voter suppression and bills to try to encourage same-day registration. I've already talked to you about automatic registration and how that works. So again, this map here is just really showing you kind of how we've moved forward in terms of expanding AVR since 2015. As Wendy said, Oregon was one of the first, in California, and then you see coming up to 2017, many more states have followed suit. And really, this is also the story of voting rights in 2018. It's not just what happened after Shelby. It's not just what kinds of restrictions have states been putting in place. It's also what is the reform agenda and what should it look like. I always like to say this is a bad news, good news paradigm. The bad news is that yes, we have been dealing for several years with efforts to make it harder for people to register to vote and indeed engage in our election system. But the good news is that across the states and on the federal level, there are many efforts in place, bipartisan efforts, to ensure that we make it easier for people to engage in our election system and again, expand the franchise, which, as I said, is really at the heart of our democracy. So I'm going to stop there because I know my friend and former colleague Justin is going to get into the nitty-gritty of some of the litigation, which undergirds a lot of this. But again, I want to leave you with this triumvirate, which is this issue is about what is in place to make it harder for people to vote, but what are we doing as a nation to expand that franchise? And that there are many efforts underway to do just that, to protect the electorate. And thirdly, that we have to start talking about how do we just get more Americans engaged and make them understand and realize that this talk about voting is not just something that's fun for those of us who are election, quote unquote, experts, but it's really at the heart of our democracy and what makes our country tick. And it's really something that we all have a vested interest in protecting. So with that, I will turn it over to Justin.
True enough, and a great lead. So I want to, as the slides are coming up, I want to offer my thanks, just like everybody else did, to the Seventh Circuit Bar Association. It's really a delight to be here. I spent several wonderful years in Chicago, and so it's really nice to be back. Even in January, it's really nice to be back. I also want to thank Ami and Nicole and Wendy for such a wonderful sort of lead up to this. You've heard the numbers and you've heard the words, and so now it means it's time for the irrelevant anecdotes. I'm going to talk a little bit about the litigation that's been surrounding all this. You've heard a lot about legislation and policy, both of which are exceedingly important. I'm a law professor at Loyola Law School in Los Angeles. I'm also a litigator and have brought voting rights cases. I've sued election officials. I've represented election officials. They like it better when I'm representing them than when I'm suing them. I just got back from a stint at the U.S. Department of Justice in the Civil Rights Division, actually helping to support and supervise the voting rights work of the Civil Rights Division. I've litigated on campaigns in a lot of different hats. I've dealt with the court system and how the courts interact with everything you've just heard about. And I have to say, it's really much nicer to be sitting up here. This is not a perspective I'm used to when talking about litigation in the voting rights system. I want to set the context a little bit in a way that is absolutely consistent with what you just heard from Nicole and from Wendy, but a little bit different. And the context for the litigation is the following. I'm sorry to have to show you this in Chicago. This is the 2016 presidential election results. I know this is very familiar with you. I want to give you a different way to look at this map. This is a map of the 2016 presidential election if did not vote were on the ballot. And that should be terrifying. The election was won by did not vote in the vast majority of states. And that should be exceedingly concerning no matter what party you favor, because no matter what party you favor is losing in this graph, in this map, in this chart. Now, some of that is doubtless due to particular candidates. Right? Enthusiasm varies from election to election, not just in a presidential election. I wish that we could have the same level of engagement that we had in 2016 in any midterm or any municipal election, for example. And some of this is due to the weather, and some of this is due to all sorts of vagaries of the system. I do not want to say that the reason we have this map is because of election administration, but the structure and the setup, exactly as you heard from Nicole, plays a role in the fact that did not vote won this past election, as it has won the vast majority of elections across the country forever. For those of you that are old enough or less traumatized than some of my students, who are neither old enough nor as traumatized by this as they should be, this is a picture of one of the election judges in Florida in the 2000 election. We know about the 2000 election because we know that it was broken. We know that it was broken based on hanging chads, right? That's the thing that all of us learned about that none of us thought we ever had to know about. Turned out there were problems in voting technology, there were problems in voter information, there were problems in the recount structures, there were problems in deadlines. All of those things made it very prominently into court. But for anybody who has worked on elections, including and not limited to the 2000 election, you know that these are only the problems that made it to national TV. The 2000 election in Florida was massively overdetermined. The margin of error vastly exceeded the margin of victory. And for those of us watching, these were the problems in 2000. In Florida alone, if you add other states around the country, I've got a few other things that worried people in 2000, not just in the presidential election, but up and down the ticket. These are the sets of issues that afflicted the system, that contribute to the fact that did not vote is winning our elections consistently. Now it's 2016, and the good news is we fixed hanging chads. The bad news is this is the list of issues that I worried about in 2016. And I guarantee you, every single one of them affected an election, not for the better, somewhere in 2016. I can't always tell you exactly where each issue affected an election, but all of them affected an election somewhere in 2016. So we got a lot of work to do. And if you add the other things that I worried about in 2016, I tacked on a few extra things that didn't really hit consciousness in 2000, the list gets even longer. That leads to the election administrator's prayer. Lord, let this election not be close. And when I show this to election officials, they start smiling, not because they're unfamiliar with this motto, but because they haven't seen it cross-stitched on a pillow before. But we should not be relying on, Lord, let this election not be close in order to tell us how we are running our democratic process. And that is too often what we escape with. It's not that the elections following 2000 were cleaner than the election of 2000. It's just that they were less close. So these are the list of issues we still have to fix. This is where there was litigation. Let me show that to you again. These are the issues we still have to fix. In 2016 alone, all of the issues in white were issues where there was litigation. So the good news for the attorneys in the crowd is there's plenty of business. The unfortunate news is there's plenty of business. Right? There were only a few things that I'm not aware were litigated in 2016 on this list, and I might well be missing some. It's tremendously difficult to track state court litigation, particularly leading right up to election day. So it's entirely possible I missed some. In 2017, actually, some of these things were litigated, so I can probably take them off the list. Here's the upside, or at least some upside, for those of you that believe in the judicial system. The items in gold are issues where the courts, either statewide or countywide, granted relief. So it turns out that the litigation is, to some degree, working. Not everywhere, shouldn't work everywhere. Not all cases are good cases. But courts are actually finding their footing in standing up for the application of law such that eligible voters tend to be voting more often after the courts get involved than before. Today, I want to focus on two things. They're fronted in the topic for today, and you've heard a lot about them already. I want to focus on litigation over voter ID and litigation over voter registration, but I would happily return in the questions and answers to any of the items on this list. We all, actually in various shapes and sizes, deal with most of the items on that list. Litigation over voter ID and litigation over voter registration very quickly, because I know I don't have a lot of time. This is the map of states with some sort of voter ID rule. Every state has some sort of voter ID rule. Every state has some way of making sure that you are who you say you are. And Wendy's absolutely right. These divide into categories. I'll get to the categories in just a second. There are some states that don't require particular cards or particular documentation, but every single state has some way to ask you who you are and to make sure that you are who you say you are. And all of the states, there's a federal law that says for some voters, all of the states have to abide by a federal law that requires those voters who register by mail, to prove their identity at some point before they cast a valid vote. So the fight over voter ID is not a fight over whether there should or should not be voter ID. Just like the fight over taxes is not a fight over whether there should or should not be taxes. Even the people who are against taxes want there to be some taxes. The question in voter ID cases, the question in voter ID policy more generally, exactly as Wendy said entirely correctly, is in the details. What kind of security is being implemented, and do those particular constellation of provisions shut people out who don't have ready access? And as Nicole mentioned exactly correctly, the people who tend to be shut out first are those who are otherwise on the margins, those who are poor, those who are either very elderly or very young, those who are either extremely urban or extremely rural, and often that falls on the shoulders of racial and ethnic minorities. The fight over security, the fight over voter ID really comes down to, or should come down to, an analysis of costs and benefits. Many of you live in houses or apartments where you have windows. Somebody could throw a rock through those windows, but you probably haven't bricked in your windows yet because you like having windows. It's a cost-benefit analysis. If there was somebody standing outside your window all day, every day, throwing a rock at it, you might take extra security precautions, but you're gonna have to weigh whether those security precautions are worth the benefit that you get on the other side. So too with voter ID, and in fact, that's the litigation posture of a lot of ID laws, is trying to decide whether the security measures put in place, whether the particular provisions of any ID law are worth it, whether the burden is undue in terms of the constitutional test. These are the states that implemented in the last 13 or so years. Indiana was one of the first. Some of the most restrictive voter ID laws. There are states, some of them still on Wendy's list of the strict voter ID laws. And you see already the picture changes. Right now, we're not talking about every state in the country. Now it's a relative handful. And when you look at judicial action, the picture changes still yet again. So the states in purple are the states that still have relatively strict voter ID laws. Georgia gets an asterisk because the courts pushed back on implementation for a couple of years. Virginia gets an asterisk because its list of acceptable IDs is quite a bit broader than some of the other states. The states in pleasing yellow or gold, or I don't know what kind of ochre that is, depending on what your monitor says. The states that are yellowish are states where the courts actually led to significant mitigation of a restrictive voter ID rule. I include Wisconsin in that. One of the main problems in Wisconsin, the law is actually much better now. It's the bureaucratic implementation that's the problem. And the fact that people don't know that the law is better now. That tends to be a real serious problem. And the states that are palest, Pennsylvania and North Carolina, are states where the courts struck down the existing harsh voter ID rule, returning to the status quo. Remember, every state has some system. So in North Carolina and Pennsylvania, it's not that they have no voter ID rule, it's just they had the less restrictive rule that was in place beforehand. The courts are, to some degree, pushing back on the most restrictive. What do they use to get there? A couple different avenues, and you all as litigators should know. that not every case should succeed. There are lots of different bases for claims. There are federal constitutional causes of action, sometimes based on an undue burden theory, sometimes based on intentional racial discrimination, sometimes both. There are causes of action under the state constitution. Several ID laws have been struck down under state constitutional requirements. There are causes of action under federal statutes like the Voting Rights Act. But also in the mix is the particulars of the ID law itself, right? You cannot take a cause of action and shop it around the country to very different laws in very different places. The nature of the impact those laws may have, the nature of the evidence that it's possible to muster, the nature of the implementation that the state has used in order to put its ID law into effect, and last but not least, familiar to all, the quality of lawyering. There was a case in Oklahoma, which has a relatively broad ID law. It requires identification documents, but not as strict as some of the others, brought by a woman who had and showed the very ID that she was saying it was not permissible to require. So, a woman who had the ID required brought a case in Oklahoma saying I shouldn't have to show it. That's not a great case. Not great cases happen. There was a lot of publicity. The Seventh Circuit has been involved in litigation around this issue, as you know. Indiana had one of the first of this new round of more restrictive voter ID laws. There was litigation that went up to the Supreme Court. It did not say that voter ID laws as a category were perfectly constitutional and lawful. That case, as all cases do, dealt with the facts presented to the court and said that the plaintiffs had not met their burden to show, to prove that the law was unconstitutional or otherwise unlawful. That is, the case actually, if you read it, it stands for the remarkable proposition that plaintiffs need to have evidence in order to win a case. There has been a lot of controversy, actually, over Judge Posner, who heard a version of the Indiana laws that came up through the Seventh Circuit and rejected the claims. And then later in the press and in public writings, he does a lot of that, stated that he felt that the ID law was in fact far more restrictive. And he was criticized for what many called an about-face, a reversal, or lauded for what many called an about-face or a reversal. He's finally recognized. I actually don't think it was an about-face or a reversal. I think that in his judicial capacity, he was analyzing the evidence that was brought forward to him and found it insufficient to find a legal violation. And I think in his public capacity, he was analyzing the evidence that he had collected, that others had collected, that studies had shown, and found that it had an impact that was not presented to the court, at least not adequately. And that was, as a policy matter, a bad idea and perhaps unlawful in a different incarnation. That is, I don't think Judge Posner before and after is a change in position. I think it's a change in role and shows that the nature of a case can make a huge difference on whether a law is lawful or unlawful, whether a law is upheld or struck down. You all know that. That's nothing new, but it seems in election policy areas, we all shut off that side of our brain and pretend that any given case is a solemn intonation about whether a policy is lawful in the abstract or a good idea in the abstract. It's useful to remember that just like in any other piece of litigation, litigation can be successful or not based on the particularities of the policy as it's implemented, the evidence that can be mustered to show an unlawful effect, and in fact, what the law actually prohibits. It's not news, but it's worth remembering in this context. Wisconsin is currently, I think, either Wendy or Nicole or both mentioned that it has been bouncing around the courts. It's still bouncing around the courts. There is active pending litigation. It's getting on about a year since there was argument in the Seventh Circuit over the latest iteration of Wisconsin's law. The court has the case. I don't know what they will do with it. There is continuing litigation in state court about the implementation of Wisconsin's law. Stay tuned. Election cases sometimes are resolved from trial to Supreme Court weigh-in in the course of a week. That happened in Ohio in 2004 and made for a lot of sleepless nights for a lot of people, but more often linger for years. I know you've had, in the first two iterations of this series, conversations about redistricting and gerrymandering. And there are some of those cases that are moving very quickly. In Texas, we are still fighting today in 2018 over lines drawn in 2011. And chances are real good that nothing will change until 2020, at which point we start the cycle over again. So many of these cases take a while to resolve. Wisconsin's no exception. That's just a short bit on ID. I also want to talk about voter registration and the litigation on voter registration. You heard the Chief Judge mention a case argued. It is an interesting time to be in this business. There's a lot of action going on. There was a case argued at the Supreme Court earlier this month on the National Voter Registration Act. Very briefly, before Margaret gives me too stern a look, the National Voter Registration Act of 1993 is federal legislation. It covered a lot of ground and is relatively rare because most federal legislation on these sorts of issues don't cover quite as much ground. It was essentially a big compromise. It wanted to make the rolls more accurate as reflecting the eligible population. And so what it did, it had several provisions to make it easier for more eligible voters to get onto the rolls, and had several provisions designed to make sure that ineligible people would be kicked off the rolls, but only when they became ineligible. And both parts of that equation help make the rolls more accurate. More eligible people on, ineligible people, but only ineligible people off. And that's a change. Before the National Voter Registration Act, some states just purged the rolls, all of them, every couple of years. You had to re-register every so often. National Voter Registration Act says, no, the rolls should be stable. We'll bring people on as they become eligible. We'll kick people off as they become ineligible. But you only get to purge the rolls when somebody's become ineligible. The basic structure of the NVRA. There has been a bunch of litigation around each side of this. There's been a bunch of enforcement litigation against states that have not adequately brought people onto the rolls. You know the National Voter Registration Act perhaps by its motor voter moniker. DMV offices have an obligation to present voter registration opportunities. There's been litigation over the extent to which they're actually doing it. Social service agencies, disability agencies have the same. There's been a little bit of litigation about coming off the rolls too. That process is much like surgery. Keeping the rolls clean, if you do it properly, is a good thing. But you want a well-trained, highly skilled surgeon with the right tools and the right environment doing the cleaning. A surgeon takes out a tumor, that can be life-saving. A surgeon takes out your heart, unless he puts it back real quick, that's not a good idea. And so when surgery is done badly, we see litigation over the attempts to clean the rolls or purge the rolls without making sure it's limited to ineligible people. In 3 seconds, I'll give you a short view of what the Ohio litigation is like right now. It's mostly about movers. A lot of people move in this country. 7% of people move within the county every year. 2% of people move outside the county within the state. 2% of people move to a different state. That adds up to a lot of people. In addition to that, there are people who look like they move but don't. There was a big hullabaloo in 2008 when Washington State tried to clean the rolls, Montana, pardon me, tried to clean the rolls, ended up kicking off a lot of people who were reservists deployed overseas, who sent their mail to live with their parents while they served in the military. They looked like they moved, at least to a state that wasn't real focused on making sure that they had become ineligible because they changed their address. But they hadn't actually moved, it's just their mail did. So part of the question of this process is how to deal with movers so that we only kick off the people who are ineligible. The NVRA sets up a structure. If you believe somebody has moved, we gotta be sure. So you can't purge them right away unless they tell you they've moved. If it's secondhand information, you have to wait for 2 election cycles. If they haven't showed up or otherwise interacted with the election system, then you can purge them. Most states, Ohio included, ask for evidence that somebody has moved, affirmative evidence that somebody has moved. If that evidence comes in, a letter that is returned undeliverable, Postal Service can't deliver, or a change of address in the Postal Service, or some other indication that somebody has moved. Once that evidence comes in, wait 2 cycles, make sure it's solid, and then purge. Ohio also has a supplemental process, what's known as a supplemental process, about 7 or 8 other states do, where they started the 2-year countdown, the 2-cycle countdown, by taking people who hadn't voted for a while and who hadn't answered their mail in a while, mail from the elections office, and then waiting 2 cycles and purging them. The question up at the Supreme Court right now is whether this is legitimate evidence that somebody has become ineligible to vote, or whether it's just evidence of inactivity. I have a pretty strong view on this one. I helped to write some of the briefs at the Sixth Circuit, which obviously got the answer correct. The Supreme Court is now evaluating whether the Sixth Circuit got it right or not. I will tell you, the NVRA is not a model of clear legislation, and so there is a lot of meat for both sides. I happen to think that if you look at what the NVRA was trying to accomplish, that this answer is pretty easy, that you need some evidence that somebody has become ineligible before you kick them off for having become ineligible. But we'll see. That's one of the hot button items up at the Supreme Court that we're going to hear more about this spring. And with that, I want to leave it, make sure we have ample time for questions.
Thank you. Thank you to all of our speakers. Let's give our speakers a round of applause. Well, I heard a lot of great mentions and summaries and analysis about different types of voting rights related legislation that's on the table here or elsewhere. And I would appreciate if each of the speakers could give a couple of specific examples of particular communities or populations of ours who are affected, who would be affected in particular ways if such laws were enacted. And I would challenge you to think broadly too about not just what has to be a complicated piece of legislation, but it could also be an administrative fix. I know that that aspect of elections is very important in places like Illinois, Indiana, other places as well, and can be the source of a lot of positive changes. It doesn't only have to happen through legislation. So when we talk, a lot of people here, I see a lot of familiar faces, a lot of people here are concerned about the community impact of voting restrictions and of voting innovations and solutions. So if we could hear a couple examples from each of you about particular populations and communities who are affected now or stand to be affected by some of the positive changes we could implement. Do you want to start, Wendy?
I'll start with people with disabilities, and those of us who think we don't have disabilities, we just need to get a little older and then we will. When you move to an all-male voting system, which 3 states, including Colorado, where I am, you're sending out paper to people with disabilities, and paper is not a friendly technology for people with visual impairment or with dexterity issues. There are possibly other fixes for it, and Maryland and Utah and New Mexico are looking at online ballot marking opportunities for people with disabilities, and that starts to look like internet voting. Maybe that's the right fix, maybe it's not. I'm just proposing that people with disabilities is a group of people who can be impacted in any law, whatever it might be, whether it's registration or ID, or as I suggest here, that's a group of people to take into consideration and ask, what will this do for people with visual or physical or cognitive disabilities?
Thank you.
I'm going to give 2 examples, one that deals with how a huge swath of people could be helped, and another looking at a specific community. With our research at the Brennan Center with respect to automatic voter registration, our research has shown that if we had automatic voter registration enacted across the entire country, that up to 5 million eligible voters who are not currently on the rolls, but who otherwise are eligible to be registered voters with the use of automatic voter registration would become eligible voters. And that doesn't matter what kind of voter you are, what class you're in, what sex you're in, what race, anything, that overall, up to 5 million more eligible voters would get on the rolls through the use of automatic voter registration. That's huge. Then specifically, and I know this is going to come up at your next series, but I think it's a very cogent example. And I'm going to look at Florida, the effort to restore the right to vote to the formerly incarcerated Right now in the state of Florida, they have a ballot initiative that they just got the requisite number of signatures to put it on the ballot for the citizenry to determine whether that will change their state constitution and ensure that the formerly incarcerated who have already paid their dues to the state would have the right to vote restored. In Florida alone, if that were enacted, the numbers, and they've been counted in different ways, but it looks like probably around 1 million eligible voters, 1 million people would become eligible to vote. Could you imagine, regardless of who you voted for, what your political persuasion is, but could you imagine if just in the last election, 1 million more votes had been cast in Florida, could have swayed the outcome of the election in either direction? That's a huge number. So those are my two examples. Again, the vote restoration issue is a very specific one, but automatic voter registration is one that could completely change the landscape of the whole country.
Thank you.
So this is hard having followed those two because I agree with all of that. And by the way, on the disability issue, there's litigation on that front too. Shouldn't surprise anybody. If there's a policy, there's litigation around it somewhere. Maryland, in part based on litigation, the change, there were changes also spurred on in Ohio and in California and in a few other states for exactly that, for disability access, also in the absentee process. Yeah, if I had a single change to make, it'd be to the registration system, and if I had two others, they would also be to the registration system. Registration is the gateway in a lot of ways. About a third of the country's eligible voters aren't registered. Or aren't registered at the right place. It's really important to remember that systems like automatic voter registration aren't just for new or first-time registrants. They're to make sure that we keep up with where you are when you move. Your college, I promise, can find you. Your law school, I promise, can find you. And your government can find you when it wants. It's just that it hasn't wanted in this instance. Automatic voter registration helps it want to find you so that you continue to stay engaged once you've been engaged. And felony disenfranchisement has an appalling history. In Florida and elsewhere, lots of bills cropped up in the 1870s, 80s, 90s, 1900s, sometimes very explicitly as a means of making sure that states could disenfranchise people based on race, where they couldn't say they were disenfranchising people based on race. And if you look back at the constitutional conventions of that time, there is some profound ugliness, not just in the South. In terms of the adoption of these laws, many of which were re-adopted years later, silent on the impact or effect they were intended to have, but it's clear that they continue to have that impact today. More broadly, I think that all of our voting laws and all of our voting policies could benefit from a little bit of thought about customer service, particularly for those of us who don't look like us. So it's very natural to design policy based on what we do and imagine that that's expandable to what everybody does. And I think what you've heard in most of these policies is just a little more recognition that if we designed our election process to serve the voters and thought of it broadly, not just in what would benefit us, but what would benefit people from cultural systems or races or ethnicities or socioeconomic status different than us, that would go a long way. You could find adjustments and tweaks to virtually every policy out there that would expand access without sacrificing any reliability. So I'm going to cheat.
Thank you. That's perfectly fair. We'll now turn it over to all of you. We have a few minutes left for questions. We also have a reception following the end of this CLE where some of our speakers will be able to stick around and chat with people more. There's a microphone on the table up here, so pardon that it's a little intimidating, but please come up and grab the microphone and we would love to hear a question. And in the interest of time so that we can get hear from a few people, please keep your question brief and challenge to the speakers as well as to keep the answers brief. So thank you.
Hello, my name is Patricia Axelrod. I conduct a not-for-profit law project for the benefit of the poor and senior citizens called the People's Advocate, as well as a veteran advocacy project called the Desert Storm Think Tank and All Veterans Advocate. In a past life, I was a weapons systems analyst, believe it or not. I was a military scientist for peace, and I received a MacArthur grant as a consequence of that. Therefore, these voting machines and the systems that register voters are a snap to me. And in 2004, I brought a lawsuit against Sequoia voting system, as well as the state of Nevada, calling for the release of all of the data surrounding their purchase of the machines, as well as thereafter a request to have the machines independently tested. I won the FOIA. I lost the request to have them independently tested. Interestingly, I lost the second lawsuit because I was told by the judge that I had no standing to bring this lawsuit, which is ironic to say the least. I utilized the Uniform Commercial Code and the First Amendment in this to no avail, and I wondered I'm going to do it again. Being an Irish broad, I'm a tough broad, and I won't stop here. And I wondered if you
I want to
have,
make sure, ma'am, that we have time for your question, so
I wondered if you
please
have
share with us your
ideas on
question.
standing to bring a lawsuit to challenge the validity of the voting systems and how we can go about doing that. Standing is the issue.
Yeah, I will try to make this super quick. By saying that this is one of the areas in which litigation is particularly difficult. You only know you've been injured by a voting machine gone wrong if you know you've been injured, and trying to find out that you've been injured is part of the quest that this speaker and many others have gone through, and so you end up in a little bit of a circular structure in litigation. And so I'm gonna duck the question on litigation because I don't know that it's gonna be your most productive avenue. I'm gonna point to something that LA is doing, where I'm from now, that might actually be tremendously promising. Part of the problem with the machine structure is that there's not enough money to purchase machines, which means that vendors are not supplying the market particularly adequately. Los Angeles County is the biggest local jurisdiction in the country by a long shot. It is to elections what the Texas School Board is to educational textbooks. And 8 years ago, they embarked on a project to try and say, what would we buy if we could buy anything? They looked around, they decided, we don't really like anything. So what would we do if we could make it ourselves? And can we get vendors, if we could design it ourselves, can we get vendors to supply? That sort of demand side push into the voting system market, I think, is tremendously important and ultimately likely to be more fruitful in bringing more, not only more secure systems, but systems that people have more confidence in to the table in jurisdictions well beyond LA. So just in the interest of time, I'll leave it there, but it's an alternative way to think about the problem.
Thank you. And please introduce your name and organization for people who don't know you. Thank you.
Sharon Alter, the League of Women Voters of Illinois. My question, very briefly, is regarding election security, and I only raised the question because it was raised by one of the speakers. You mentioned Eric. I would like each of you to comment on your view of cross-check as opposed to Eric.
And keep in mind, as you all know, that in Illinois, we are a cross-check and a ERIC state.
I think that that we put a document that we put together at NCSL that compares the two onto the resources for this meeting. So a side-by-side is available to you from NCSL.
Does your organization have a position on cross-check?
No.
And I'm going to say that we don't have a position on cross-check specifically. We certainly have thoughts and opinions about its efficacy, but we don't have an opinion as to cross-check versus ERIC.
And I will add to that, because I'm allowed to have opinions about these sorts of things. List maintenance is important, and list maintenance is important to get right. And remember, I said it's like surgery. You want to make sure that you have a well-prepped surgeon in a positive surgical environment. ERIC has attracted bipartisan support from a lot of states, Republican states, Democratic states, who have bought into the system, and I mean that metaphorically. There's not actually a substantial fee to take part because of the value it provides and because it is done in a sterile, pristine surgical environment. They're exceedingly careful. Crosscheck was not built in that environment, and I have questions about the chief surgeon. Some of the questions are reflected in some recent litigation about a commission that he helped run while running for governor. I think you can see Crosscheck's efficacy through the states that have opted to leave it because the information they were getting was not sufficiently reliable to actually assist in any meaningful way with their election administration. You see a lot of states deciding on whether the information they're getting back is worth it. And frankly, many of them are deciding that it's not.
I'll add too, from the perspective of Chicago Lawyers Committee for Civil Rights, we submitted testimony to the Illinois legislature urging the state to withdraw from cross-check, and that has been an active issue of conversation among many of us engaged individuals and organizations in Illinois in recent days. We submitted that testimony in partnership with Common Cause Illinois, Chicago Votes, and other organizations. But we also think it's very important to work closely with local election authorities in crafting, well, what are the alternative and practical solutions if we have less information because of withdrawing from one program, how else can we do a good job administering our elections? And so that kind of partnership is absolutely essential, and we value it. It's also noteworthy that at least a couple of our neighboring states in very recent days have withdrawn from cross-check, so also the landscape is changing about how useful it even is in Illinois voter list maintenance.
And I'll just add one tiny little thing. All of this conversation is about an organization that helps states maintain their lists after people move and after people register somewhere else, and sort of to clean up afterward. But there are an increasing number of state election administrators and of county administrators that know that the first point of defense is you all, are the registered voters. With the increase in online registration, with the increase in contact from local administrators to the voters, they can ask you, hey, where were you registered? And that helps them get direct information on where they should clean up the list. And that ultimately, talking to you directly, is far more sound than the technological systems in the back end. And increasingly, more and more and more local election administrators are realizing they can get better information from you directly.
I want to jump in with just one more comment. It turns out there was more to be said about Eric than I realized. Eric is partly about the voter list cleanup, but there's a second portion to it, which is that states that participate are required to send a postcard out to anyone that appears to be eligible but isn't yet on the voter roll. So it's a access, pull people into the system process, and we forget that as we talk about it as
Makes the list more accurate.
Two reminders before we leave today, and thank you all for your excellent participation. I know there are more questions and ideas. We're just at the beginning of this conversation. So the first reminder is that we have a reception outside, and so we welcome you all to join us for more conversation just directly outside the courtroom. And the second is that we have a sign-up sheet outside for anyone interested in learning more about pro bono opportunities and voting rights, including our nonpartisan election protection work coming up for the March 20th election. Thank you all so much for joining us.
Thank you.